To the Honourable Leanne Dalzell.
Speaker, I'm pleased to follow from the Minister and to indicate that Labor will be supporting the reference of this bill to the Commerce Committee, where I'm sure we will enjoy the opportunity to take up the challenges that the Minister has recommended to us tonight. It's interesting because, of course, it was back in 2006 that I think I signed an MOU with Peter Costello, who was then the Treasurer of Australia, which really was the background for the introduction of this particular measure. The bill was introduced into the House just prior to the 2008 general election, and although I've expressed some disappointment that it's taken a while to get to its first reading and reference to the Select Committee, I will actually acknowledge the Minister for perhaps adding some value in the time that he has had to look at this bill, and the added value are the two issues that the Minister's asked the Select Committee specifically to look at. And I've always enjoyed myself as a Minister inviting a Select Committee to look at an issue that I don't particularly have a strong view one way or the other, and I appreciate it when that is reciprocated. And the two issues, as I understand them to be, relate to whether it is a requirement to, or whether it ought to be a requirement to have a full cooperation arrangement, government to government, as the basis for the sharing of information and investigative assistance to the overseas regulator, whether that is necessary to be in place, or whether something not requiring that sort of government-to-government arrangement, some lesser form, might be looked at. And I'd be really interested as we go through this process to perhaps hear a little more about why that might be a better approach, but I certainly don't have a closed mind to it, and it's certainly something that we'll look forward to considering. The other one that I think I heard the Minister refer to was an alternative to exempting classes of persons who are exempt from the requirement to pay any fee prescribed for an application, and that's under Part 2 fees, paragraph 13 CD. And I think that, it's interesting because I think when I had been working on this issue, I had either recently or was still the Minister for Small Business, and every opportunity that I could take, I was looking for ways of making compliance costs more manageable for the SME sector, also recognising that sometimes compliance costs can be disproportionate when you're dealing with a smaller entity that just simply doesn't have the economy of scale of some of the larger entities. And so the idea of having an exemption by regulation written into the legislation did seem to be a fair way of allowing for that to occur, but also allowing for adjustments to be made over time. The concept of having a tiered approach, perhaps that may be a better way. So again, it's not something that I have a closed mind to. I don't have a strong view one way or the other. It probably wasn't a defining feature of the legislation as introduced, but it certainly is something that we will look at the Select Committee. I think that the legislation itself, the Minister said that the Australian Government passed legislation in 2007 to enhance the ACCC's ability to provide assistance to overseas regulators. So Australia is ahead of the game. I know that he's taken the opportunity to sort of kind of reinforce the fact that the single economic markets are all the current government's idea, but we were working on the single economic market agenda, and I worked very closely with Michael Cullen on this, which is why I, as Minister of Commerce, was signing an MOU with the Treasurer as part of the discussions around the SEM agenda. Actually necessarily involved my role as Minister of Commerce on this side of the Tasman. As I think the Minister's already pointed out, the idea of the bill is to provide for the Commerce Commission to use its statutory powers to assist an overseas competition or consumer regulator with an investigation and it also sets out how the Commission can share compulsorily acquired information to assist overseas competition and consumer regulators. Now, I mean, it's obvious why we would want to go down this track. The harm that anti-competitive and unfair trading practices can inflict on an economy, but also on individuals, is significant. And I think when we recognise that businesses today increasingly operate in multiple jurisdictions, and that parallel investigations or proceedings in relation to a particular company are becoming increasingly common and complex, I think this makes very good sense to open up the regulators, as long as there is that trust in the quality of the treatment of the information that is provided. I think that can only strengthen the work that we want to be doing internationally in these areas of anti-competitive and unfair trading practices. Mr. Speaker, I would note that in the merger context, over the past, over the 2 years immediately preceding the introduction of this bill, of the 43 clearance decisions made by the Commerce Commission, 29 involved proposals where at least one of the parties was an overseas company. And in the fair trading area, many cases have also had an international dimension, and one of the examples that I was given at the time included suppliers based abroad making false and misleading claims for goods or services offered over the internet. And I think we've just seen a real growth in that particular industry, and certainly I think the capacity for our regulator to engage in a collaborative way with international regulators in terms of some of these international suppliers, I think it will strengthen the protection that's available for New Zealand consumers and also consumers in other countries as well. I've noted that the New Zealand Commerce Commission's got a pretty good track record in terms of hunting down some of the cartel behaviour that unfortunately has flourished, particularly at times when finance is tight. We do see a greater example of cartel behaviour, and if we are to recognise that New Zealand can't do it on its own when you're dealing with cartels that are actually operating internationally, then it is going to be very important to see those tools strengthened for our regulator and also for international regulators as well. So I would like to support the Minister's comments when he essentially said that he was confident that the provisions in the bill would provide a mechanism to enable genuine in-depth cooperation between the Commerce Commission and equivalent overseas regulators. It does this whilst ensuring that there are appropriate safeguards in place to protect the New Zealand public interest. And I think that that is a very strong message to be giving this Parliament in relation to this important piece of legislation. I can see how excited everyone in the House is to finally see it debated for the first time, and I look forward to receiving it at the Select Committee and hearing submissions, particularly on the points that the Minister has raised. We will support the bill.